Yes, I will.
All right, we have a motion and a second. Motion is for approval as applied. All in favor?
Aye.
Aye. Okay,
Thank you, gentlemen.
Thank you.
Yeah, very good to see you. Lots of luck to you.
All right, we're going to now discuss, I don't believe we discussed, and make a decision on the first case that we heard, which was number 4.
We had some discussion.
It just began. Okay.
Wasn't satisfied.
Yeah. Well, the first request is for variance, I believe. Yes, a variance. There's also a request for change of non-conforming use. I believe that's what I read from the notice here. Am I correct that it is not in the TNDO?
It's in the TNDO overlay, but in order for that to apply, it would have to be
At a corner.
two
Okay.
streets.
All right. Which is not, no. All right. Well, if we're talking about a change in non-conforming use based on the testimony, this would have more of an impact on the neighborhood than the past non-conforming use, which is one of the things that with a non-conforming change, we don't want. We want to have a lesser impact. Just because of the numbers and the activity, you're looking at a greater impact. If you're looking at the variance criteria, it arguably meets a number of them, but my concern is that it would be detrimental to public welfare because of we have no evidence that the exiting traffic could enter head-on to the public street, and I would be concerned about that. So I don't think it meets enough, doesn't meet all of the variance criteria as far as I'm concerned. So my inclination would be to deny.
Yeah, unfortunately, I'll have to agree. I have to thank Mr. Unger for calling to my attention section R of traffic flow. Just so everybody knows what we're calling 1321.01 R, traffic flow. Provision shall be made to allow vehicles to turn around on site as opposed to backing into traffic. The provision shall not restrict vehicles from individual dwelling units from backing onto local collector streets. Well, this is a commercial or proposed commercial use. Again, provision shall be made to allow vehicles to turn around on site as opposed to backing into traffic. And on this particular street, if it was a less busy street, I would tend perhaps not to put such weight on it, but this is right off of 7th Street. I would move to deny.
I would agree, particularly on several of the cases. One, I think, and if you use the non-conforming test, I think it fails. I think the proposed use is clearly more intense than the previous use as personal storage. In terms of a variance, there's certainly nothing unique about the lot. There might be something unique about the building. You have a non-residential building in a residential neighborhood. So to that extent, that creates some level of challenge to use the building. But even on that, because we have the most recent use was, there was a use, and someone used it as personal storage for 9 years, and clearly it's usable for that purpose. So I'm not even certain that we've met. I agree with the safety issue, but I think in addition to that, I'm not even certain that we've met the burden of a hardship. It's a regularly shaped lot. It's level, it's not steeply sloping, and the only objection we heard from the applicant that, at least from the applicant's attorney, indicating that to do a selective demolition to improve the circulation would be too expensive. Well, we were presented with no costs. The applicant did present part of the Lehigh County assessment records as part of their exhibits, and indicates that the applicant purchased the property for $50,000. So not a tremendous amount of money to buy a significantly sized lot and building that is not irregular in shape or topography. So I'm not convinced that it even meets the first problem of proving hardship. So for those reasons, I would second Mr. Salinger's motion to amend the application.
Was that, did you make a motion to that effect? Okay, and there's a second. All in favor?
Aye.
Aye.
Thank you. I guess that means we lost.
Pardon me?
I guess that means we lost.
You've been around.
Let's see. And now, let's see, I think it is, Ms. Deere, you have number 3.
Yes,
Would you like to come forward, please?
yes. You ready?
You may proceed.
Good evening.
Good evening.
I'm Denise Dieter, and I represent the applicant here this evening. We're here as a way of housekeeping. Originally, we had applied in our statement of proposed use for a special exception as well as a variance. However, our request for a variance is no longer needed because of the fact that the city on June 7th vacated the section of the alley, Jute Alley, I believe, that we needed. So all that is before you this evening is our special exception for purposes of a reduction of parking pursuant to 13210102.
So just for my clarification, so the vacation of the public street allows you to have a rear yard setback that complies with the ordinance?
Yes. And that was done, that was passed by the city on June 7th. And forgive me for not being familiar with exactly how you proceed with regard to the administrative points of the hearing. I understand you are asking who the objectors are, and I'm presuming when you say objectors, you're in your discretion granting party status?
No,
No.
no,
Okay.
no.
Okay.
No, if they want party status, they'd have to petition to intervene.
Okay, okay, thank you. I think what we'll do is we'll start with our engineer, Mr. Mark McGreggy. We have a number of exhibits that I want to make sure before I inundate you with extra copies that you don't already have what you want to present.
I would suggest if you're going to refer to exhibits in the testimony that you give us what you're looking at, because these files are sometimes difficult to get through, things get disorganized in them.
Then if it's all right, I'd like to try to mark all of them before we start.
Okay, please.
That's gonna be one.
Excuse me, members of the board. My name is Ralph Deterja, and I am here representing an objector, and I am seeking party status. I would like the opportunity to see the exhibits, and I would like the opportunity to address the issue of party status, if in fact we wish to make a ruling on that.
Who you represent?
I'm representing Mountain View LLC, who is the owner of an adjacent property across the way, owns a shopping center. It's Mountain Hill Shopping Plaza LLC.
Is it across the way, you mean across South Fourth Street?
Yes, thank you. And also Light Acadia, who is the record owner of that parcel. The owner of the actual field of the parcel. That is who I am representing.
Okay. Well, the party status would allow a party to file an appeal, for one thing.
If I may address.
Go ahead.
Party status would allow my client to participate in this proceeding,
Mm-hmm.
to examine and cross-examine witnesses, and to the extent that there were a decision that was unfavorable, would allow us an opportunity to appeal as well.
Right, okay. Did you have a comment, Ms. Deere?
I would ask that there would be testimony to document proper party status, an award of party status, actually, because we're going to object to party status.
Okay.
Sorry.
All right.
That's, if I may address as well, thank you. That's acceptable. We're here, we will put testimony on the record that we believe will establish standing for my client to enjoy status.
Okay. Do you want to do that now, or do you want to do it after the,
We can do it.
you want to participate too, so?
We're going to present a witness at the conclusion of the applicant's case.
Okay,
And we're prepared to establish the status and stand through that witness as well. So it's entirely up to how we.
all right, let's,
We're going to get it on the record. I want
yeah,
to
let's
say.
do this. Let's let Ms. Dieter proceed with her case, present her evidence. If you have any questions, you may ask them. And then, at the end of her case, we'll have your testimony on standing and decide, question of party status, whether or not we'll allow an intervention by your client is what it is. And that is what you're asking, correct?
I'm not asking for intervention. An objector who establishes standing may do so in the course of the proceeding, is not required to file a petition to intervene in an application before the board. An intervention is something that would take place at the courts if there were an appeal, perhaps, but it's not necessary for a party who appears in the proceeding and establishes as an objector standing.
I think you may be incorrect about that. So I would suggest that you request here that you be recognized as an intervener. It won't hurt.
If you want to refer to my client as an intervener, that's fine.
All right.
I'm seeking party status.
Okay.
Thank you.
Ms. Dieter?
May I enjoy a copy of the court? We have
Oh.
some exhibits.
Well, that's the crux of whether or not, I suppose, they've been granted party status. We don't have any objection. I'm not certain I have enough extras, but give me a moment to.
Well, here, we've got 3 up here. We need one.
Thank you.
I don't need this unless this is for the board. Just one.
Okay, what? Let me see what I have. I have an A1, I have an A2. Is that it?
No, there's a 3.
Is this 3?
Yes.
Is it?